back when I was practicing this stuff and actually setting these things up, I had a client call me and he had 50 properties that were in his personal name. This was right after the financial crisis. About 22 of them were underwater because they had no equity absolutely at all. We put all 22 in one LLC because if something happened to one property, there was no equity to go after the other one. So let's just put them into one LLC. Now, as those equities grew and it became a risk, then we would probably separate them out. But if you have an apartment building or a boutique hotel and you've got a couple $100,000 or $1 million in equity, I would have that all by itself because you want to isolate the liability.
All right, guys, welcome to another episode of The Report. Today, we got some sunshine and we are in the middle of November. We got a big meetup tonight, our last and final meetup of 2024. And the reason is because we are hosting a black tie holiday event this December 12th, which Mauricio is going to be a part of. I'm excited. We're giving away a 2024 Range Rover Sport to one lucky member of our mastermind community and investor community. We got the Yin Yang twins coming out to perform. It is going to be sick at a 12,000 square foot Andrew White mansion. Would love to have all you guys and gals that listen to this podcast out. It is sold out. However, if you guys want to come, email alex@summerscapital.com. That's alex@summerscapital.com. And you can get on the wait list. If any tickets come available, you can be the first to be notified. That said, that brings us to today's guest. I am really excited for our guest today. I think there's a lot of change and a lot of talk about the political climate changing. And the number one most important thing that I always say as a real estate investor, as a business owner, is to keep yourself out of legal trouble from both a liability perspective, from a perspective of raising capital. If you guys are raising capital, there's a lot of ways to get in trouble. So you don't want to get in trouble. I got none other than Mauricio Rauld. Mauricio, welcome to the show, brother.
Thanks for having me, man. It's always good to be on the show.
Yeah, man. Appreciate you. And by the way, congrats on your new book, man. Legal Strategies for Everyone. And you wrote this for Ken McElroy.
Yeah, so Ken McElroy, one of the Rich Dad advisors, I'm his legal advisor. And so as you are with a legal advisor, you got to write a book. So he's like, Mauricio, you got to write a book. And he came up with this idea of doing these strategies books. So that's Legal Strategies for Everyone. His tax guy wrote Tax Strategies for Everyone. He's writing Real Estate Strategies for Everyone. So it's got a strategies series. And that is very focused on asset protection, I will say. It's a very high-level book, but it has all the introductory topics that I'm sure we'll talk about today as well in terms of LLC formations and asset protection. There's obviously a chapter of capital raising, but even like estate planning and all that fun stuff. So it's really meant to be a sort of a broad introductory to legal topics. And I had a blast writing it, and it's had some really great reception. So super excited about it.
Yeah, absolutely. And you mentioned there's tax benefits in here as well.
No, so there's a separate book. It looks identical to that one, except instead of saying legal strategies, it's tax strategies for everyone. So that's actually Erica Freeman wrote that book.
Okay. So on the note of, setting up wealth and having the org chart and all that, I think the top of my org chart currently is a parent LLC holding LLC. And I need to set this up. I have not yet set this up, but I want to set up a living trust. What is the benefits of a living trust?
That's a great question because this is one of my biggest pet peeves of all times. A living trust is an estate planning tool, right? The sole reason to have a living trust is to avoid something called probate, which means when you pass away, you don't have to go through the timely and expensive court system and have a judge and some bureaucrats basically figure out, how to distribute all your assets pursuant to your will or whatever. It has no asset protection value whatsoever. That's the most important thing. A lot of people I talk to say, I'm good. I got my real estate under a living trust, or I got my things under a living trust. No. That's got no asset protection value whatsoever. It's merely when that unfortunate day arrives and you drop dead. That's what that is for. But I think everybody needs to have a living trust for sure, especially if you're a real estate investor, because with real estate investors, especially in different states, it can get really, really complicated. And that time frame to get your assets distributed can take much longer because you got to deal with different states. So having an estate plan, like a living trust and a will, and there's, I think, 15 other documents, man. When I set up my estate plan, it's like a power of attorney, a medical thing in case something happens. There's a ton of stuff going on there.
Okay. Regarding the living trust, what is the difference between a revocable living trust and an irrevocable living trust?
A revocable living trust or a revocable trust is one that you can change, right? So you're the trustee, and if you want to tomorrow add your kids or take your kids off or add assets or take assets out, you're in full control. An irrevocable trust is one that you cannot change, right? So once you set it up, it's kind of etched in stone. And that's what gives it sort of the asset protection piece. Is the irrevocable trust is what we use for asset protection trusts, which are very, very powerful. A little bit next level, I would say that's asset protection 202, not for somebody just starting out. But if you've got you've accumulated wealth over the years and you've been a real estate investor for many, many years and you have a sizable estate, then an asset protection trust is definitely something you need to look into.
Yeah, absolutely. Can you give me an example of like someone that would set up a revocable versus an irrevocable?
I think every single real estate investor should have a revocable living trust.
Mm.
Again,
Why,
just
why is that?
for estate planning purposes. Like if they pass away, if you go through probate, Rich, it's going to take you 6 months, a year. It's going to take you a long time to get everything through the process. It's going to cost you money and it's not private. So everybody and their mother is going to know all of your business, what your assets are, who they're going to. So with a living trust, you bypass that whole court system. It's much cheaper, and your heirs, whether if you're a single guy, it's your parents or whoever you're giving to, they get their assets, they get distributed your assets much, much quicker, cheaper, and in a private manner.
Got it. Okay, so if I was to set up the trust, would that trust it would hold my parent LLC?
Correct. Yeah, a living trust would be, it just replaces you, the individual. So if you have a holding company like we've talked about before, I'm happy to talk about it again, then the living trust would own 100% of your holding company in Wyoming or whatever great asset protection state we choose.
Okay, so next up in the org chart, every investor out there should have a parent LLC or a holding LLC, and ideally you set this up in a state that gives you protection from both the inside and the outside attack. What the heck does that mean?
Yeah, so when we're looking at asset protection, you're always looking at inside attacks and outside attacks, right? An inside attack is an attack that happens relating to the property itself. So we're talking real estate. So somebody slips and falls on your property, it's related to your property. So a boiler explodes and injures the family, it's related to your property. That's an inside attack. And generally speaking, the owner of the property is legally liable. So you don't want to own that in your personal name. You want to own it in some sort of an entity. Typically, we use LLCs, limited liability companies. But what happens if something happens to you unrelated to your properties? You get into a car accident, a business dispute, a divorce, or what have you. Then people will get a judgment against you first and then go looking around what can they collect. So they'll see what assets you have, what real estate you have, and they're going to try and attach the real estate. That's an outside attack. And holding companies are at the top of your org chart. Those really address outside attacks. Those address scenarios where you get into legal troubles, lawsuits unrelated to your properties. And so you don't want to own, not only do you not want to own the property itself, you don't even want to own the LLC that owns the property. You want to own the holding company, your parent company that owns the LLC that owns the property. And the key here is, and you've probably heard this before, the key is to have this, what we call charging order protection, right? Because what we want to have happen is when there's a judgment against you, I always pick on you, Rich, but if there's a judgment against you, Rich,
let's do it.
I have $1 million judgment against you. I'm going to want to get my hands on all of your assets, all of your LLCs, so I can then liquidate and get my judgment paid. But with a charging order, I don't get control of your LLC. I don't get ownership of your LLC. I just have like the financial rights. It's almost like I have a lien on your LLCs. And so to the extent you would distribute any monies to yourself, that has to get diverted to me and pay my judgment. But I don't get to control it or own the entity. As opposed to other states that don't have charging order protection, I'm just going to go to the judge. California is a good example. I'll go to the judge and say, Judge, Rich over here owns this LLC. It's got a beautiful boutique hotel in there. I want that LLC. He owns 100% of it. And the judge will just give me a turnover order, which says that you have to turn over your LLC, your ownership in the LLC over to Mauricio to satisfy your judgment. Now I own your LLC, and most likely I'll just go fire sell it so I can get my judgment paid. So you always, on the parent company level, you want to pick a state that has charging order protection as the exclusive remedy, where that's the only remedy somebody can get if they sued you. And about half of the states actually have charging order as the exclusive remedy. But to go a step further, something like you're Rich, single guy, charging order doesn't make sense for single member LLCs. The whole concept of what a charging order is doesn't really extend the logic to a single member. So a lot of states don't extend charging order protection to single member LLCs, or even husband and wives, because that's also considered a single member for this purpose. So there's a few states that have actually changed their statutes to extend charging order protection to single member LLCs, even though it makes no logical sense.
So for someone listening to this podcast right now and they're a real estate investor, they want to open up a parent LLC or a holding LLC, which states are the best states to open the parent LLC or the holding LLC in?
The best states to open a parent LLC or holding LLC are Wyoming, Nevada, Delaware, and Texas.
Now Texas.
Texas, as of September of last year, so just over a year now, they amended their statutes to extend charging order protection to single member LLCs. So if you're the only person, or you just have a husband and wife, you don't have a business partner, which is really what charging order is there to protect, then you're going to have the same protections that you do with a multi-member partnership. Most other states are silent on it, and it really just depends on whoever the judge is. They may or may not extend that charging order protection. That's why you always hear Nevada, Wyoming, Delaware, Texas now joins that elite group.
Mine personally is in Wyoming. We have some entities that are set up in Delaware. I'm curious for you, from a cost perspective or a annual franchise fee perspective, is there one of those states that you like best?
My favorite state to set up holding companies is Wyoming for various reasons. Number one, the cost. It's super inexpensive. It's literally $100 to file and $50 to renew. Delaware has franchise taxes. Delaware has an archaic way of forming them, and it's just you can't even fax things, or everything's got to be overnighted. It's just a pain. And so there's no different from an asset protection standpoint between Delaware. People love Delaware, or businesses or banks love Delaware because they have a very specified court system that really addresses business disputes. So if you're going to have your bank, for example, wants to come after you for some lending thing that happened to your lending agreement, they a lot of times want to have that agreement in Delaware to get the protection of those states. But you and I, we don't care about that. We want to make sure it's simple, private, easy to do. And to me, Wyoming is hands down even Nevada. They started charging you all of these licenses, business licenses, and it's hard to get a nominee. Wyoming is cheap, fast, and maybe even more importantly, super private. Like the state of Wyoming doesn't even know who you are. Like they don't ask, if you've noticed, when you file that LLC in Wyoming, they don't ask you for your name anywhere. They don't ask for the members. They don't ask for the managers. You're not your own registered agent. There's nowhere for them.
And the formation is almost instant.
You do it online now. You do it online. Yeah. I don't have a problem with that. In fact, a lot of people ask me, hey, can I use LegalZoom or I'm like, if you know the important information, which is the hard part, where to set up your LLC, who should own it, who should manage it. Once you're armed with that information, just go on the Secretary of State website and just do it yourself.
Yeah. So to recap, open a parent or holding LLC, Wyoming, Delaware, Nevada, now possibly Texas. But from a annual tax perspective, Wyoming is your favorite.
Yes.
And you're saying if there is a lawsuit or some sort of outside attack, and someone hires an attorney to pursue some sort of legal settlement, that attorney is likely going to look up your parent LLC and discover, okay, it's in Wyoming. It's not worth our time. It's not going to be a good chance that we're going to win this. I don't suggest for you to pursue. Likely could happen.
Let me role play for you. I get a judgment against you. I bring you in for a deposition, basically, and I say, what do you own? You say, I own a Wyoming holding company. If you're under oath, I go to the judge. The judge, hand me his ownership in the Wyoming holding company because I want it. The judge will say, no, you are not entitled to get ownership. You're not going to control. I'm going to give you a charging order, and that's just going to give you a lien on your distributions. But why would you give yourself distributions if that's just all going to go to your creditor? So you cut off distribution. That really frustrates the creditor. And either if you've gotten that far, they're going to settle for pennies on the dollar. And if you're talking to a plaintiff's lawyer on the front end, they're not going to want to pursue something where they're not assured of collections because they all get paid on contingency, which means they only get paid if you get paid. So a plaintiff's lawyer, and I used to work for one, they don't want to take cases unless it's an easy collection for them. And when they see Wyoming or Asset Protection Trust, if you have an insurance policy, man, they're just going to take the
They're
insurance
not
policy.
interested.
Yeah, they're
Okay.
not interested.
On the annual franchise fee, the annual franchise tax note, I'm curious because we just consolidated all our LLCs. We put them under one company to manage and handle all the taxes for us. But prior to this, we had some LLCs with Corporate Direct. We had some with Prime Corporate Services. We had some with SEC councils that had set up syndications in the past. And so I'm like, it just started to be, it was the Corporate Transparency Act, which was actually got us to take action on this. We're like, let's just move it under one roof. It's better to be organized. Now, I was always curious if we missed the annual fee on an LLC, because we had overlooked some of them in the past. It's bound to happen. At what point does all that liability and asset protection, boom, that goes away if you miss an annual fee and that sort of thing?
Yeah, in Wyoming, for example, if you miss your annual fee, it becomes administratively dissolved. Now you can get that reinstated pretty fast for 2 years. Once you pass 2 years, you're done. You got to get a new entity. So yeah, if you want the asset protection, it's very important for you to keep those LLCs in good standing, because if they're not, you may lose that protection. Sure.
Yeah, because if you got them under 5 or 6 different places, I'm like, it's easy to lose track. You got a lot of things going on, and we have in the past, but luckily we caught them right away. But now that they're all under one roof, I'm like, I don't think that will ever happen. These third-party companies are pretty good. Like Corporate Direct, for example, they will pay all the annual fees on your behalf. They'll collect all the mail on your behalf. And then they'll just shoot you a bill once a month, and it's like it's basically a cruise control. You don't need to worry about it as a real estate investor,
Yeah,
which
that's
is
how they get paid. So they
yeah,
want you to make sure that you're on top of it and renew their registered agent fee and make sure everything's handled for sure.
yeah, absolutely. Okay, another question for you that comes up a lot is and I've heard a lot of people ask me this question, and this comes up whenever we're doing K1s and or every time we got to file taxes every year. If you have an LLC that's, let's just say, Wyoming, but you're doing business here in California, does all those entities need to be registered in California and pay the $800 annual tax in California, even though it might just be an entity that's in Wyoming and it's not really doing business here, but theoretically it is because you do a lot of business here?
Yeah, so a holding company by definition doesn't do any business, right? So a holding company merely holds other assets or really holds other LLCs. So my argument is always it's not doing any business, let alone doing business in California. Now, however, the franchise tax board is extremely, extremely aggressive, and they will take the position that even, first of all, if you look in the direction of California, you're doing business in California. But if you're the owner or the manager, ultimately the owner or the manager, they do take the aggressive position that you are doing business in California, even though that makes no sense. Most states will not take that position. But what are you going to do? Go fight the state of California because you don't want to pay $800? So what we typically do, though, that's only for the holding company. So if I'm creating, and we talked about this the other day, when you're buying property, right, the property is going to be in a property LLC, right? That's going to be owned by the holding company. That LLC is most likely to be set up in the state where the property is located. So if I have California assets, California properties, I'm going to put those California properties in California LLCs and have those California LLCs be owned by my Wyoming parent company. That's how we do that. So a property LLC gets formed in the state where the property is located. The holding company gets created in the state, one of those great asset protection states. And then there's the businesses, right? The management companies, the property management companies, all the active businesses, those get set in the state where you're actually doing business, which is generally in the state where you reside, where your butt is, because that's where you're actually conducting business. Now, you might be a property manager and you may be managing properties in a lot of different states. And so you would have to qualify to do businesses in all the states. But when we set it up, I generally would say, Rich, where do you live? And you say, well, I live here in California. I would just say, let's set up a California LLC as your management company because they shouldn't have any assets. Your businesses, your active business should own nothing. I should be able to hand over the keys if something were to happen. So the key to asset protection is to separate the dangerous businesses, which are your businesses, your active businesses, with the valuable assets, which are in the holding company. So always keep those separate. That's kind of my asset protection 101.
Yeah, I love that. Talk a little bit about the risks of having a property, even a residential piece of real estate under your personal name versus an LLC. What are some of those risks?
You should never own a piece of property in your personal name because if something were to happen to the property, you have unlimited exposure. Some people fall into the trap of thinking that, hey, I've only got $25,000 in equity, or sometimes I'm underwater. There is no equity. It doesn't matter. If I slip and fall on your property and I break my neck, or I've got like a $10 million judgment against you, I'm going to go to the property first for sure. But if you don't have any equity in there, you're liable personally. So I'm going to go after you personally. And at that point, hopefully you've got some insurance because insurance is always your first line of defense. Maybe even an umbrella policy, great. But then you want the backstop of the LLC because what the LLC does, by definition, it's a limited liability company. It limits your liability to whatever's inside of the LLC. It doesn't extend over to you and your other assets. So it's very, very important to not own your properties or really any risky asset in your personal name. Have it in the name of an LLC.
Now, when you're buying commercial real estate, a lot of these commercial lenders, they will lend to an LLC, and then you can personally guarantee it as the individual or as the borrower or as the loan guarantor. However, when you go and get a residential loan that's conforming to Fannie and Freddie, often these residential loans will require you to take title under your personal name. Do you suggest someone that has a mortgage that's 3, 4, 5 years old under their personal name to transfer title into an LLC, even though in those loan docs it might say, hey, we have the ability to call the note due if you transfer title out of your personal name?
Most real estate investors, if not all, will take title in the personal name because they have to, and then they'll create an LLC, and they will transfer ownership from the personal name into the LLC for the asset protection. Now, you mentioned something that's in pretty much every single loan document is a clause. It's called the due on sale clause, which gives the lender the right but not the obligation to call the note. I've yet to see anybody call that note on a due on sale. When you transfer, and this is important, when you transfer the property from your personal name into your LLC, the due on sale clause is really meant to avoid me transferring it to third parties and wrapping the loan from something back in the 70s. But Fannie and Freddie have in their guidelines, as long as you're transferring it to an entity that has the same ownership as your title. So if I own the property 100% myself, I transfer to an LLC that I own 100%. Or if I own it with two people 50-50, I transfer to an LLC that's owned 50-50. Then even the Fannie and Freddie guidelines dictate that lender should not do the due on sale clause. And like I said, in the 20 some odd years I've been doing this, I've never seen a due on sale clause get called on a transfer to your own holding company, your own LLC. I see it when people do other things like subject to, or they're literally selling it to third parties. But even then it's really rare. But when you transfer it to your own thing, it's for asset protection purposes for yourself. I've yet to see it called.
I got a couple that I got on these Navy Federal Credit Union loans like 4 years ago that I got to transfer. And so that's really what got me thinking about that. So I got to just set it up and do it. Would you say these are both short-term rentals here in San Diego?
Yeah.
Which is even more liability.
Yeah.
Right?
Yeah.
And yes, I got a good umbrella policy, but those are the only two properties that I have that are not held in LLCs. So would you say put both of those into one entity or two entities individually? And would you recommend I put those in a California LLCs or Wyoming?
Great question. The question always comes up is, how many properties should I put in one LLC? That's a great question that get asked all the time. It really depends on every single person. And all you need to understand is that whatever's inside the LLC is fair game. So if you put two properties in an LLC and something happens to the first property, the equity in the second properties would be fair game if there was a judgment. So you have to make your own decision whether you're comfortable with that or not. It's just a risk analysis, right? You could put three properties in one LLC, but if something happens to property number 1, 2, and 3 are exposed. So to me, it's more about how much equity are in the properties, because if there's a little bit of equity, it's probably not a big deal. You can put multiple properties. I'll give you a great example. Back when I was practicing this stuff and actually setting these things up, I had a client call me and he had 50 properties that were in his personal name. This was right after the financial crisis. About 22 of them were underwater because they had no equity absolutely at all. We put all 22 in one LLC because if something happened to one property, there was no equity to go after the other one. So let's just put them into all in one LLC. Now, as those equities grew and it became a risk, then we would probably separate them out. But if you have an apartment building or a boutique hotel and you've got a couple $100,000 or $1 million in equity, I would have that all by itself because you want to isolate the liability. But it's really more of a risk thing. And then from where to set it up, again, my rule of thumb is the property LLC will be set up in the state, so it would be California, and then just have your holding company or your parent company
be the owner of
the
it.
owner of the LLC.
Okay, I got to set that up ASAP, and it sounds like it's a relatively easy process. Now, transferring title from personal to an LLC, who does that for you?
That's usually a transaction. Sometimes it's even title companies. I would be careful, and I'm not a transactional attorney. I would be hesitant or just check with your attorneys about using a quitclaim deed. A lot of people just say, oh, let's use a quitclaim. And there's some issues with title, and you may lose some protection. So just hire either a transactional attorney or a title company to draft a deed that transfers title from your personal name into the name of the LLC. That gets recorded with the county recorder's office, and you're done. With holding companies, it's even easier because you're just transferring LLCs. And so that's just an internal document that says, hey, this LLC, instead of being owned by me, it's going to be owned by this new LLC. And so that transfer is not even recorded anywhere.
Yeah. Okay.
Yeah.
So I've heard you say in your content before, you should never form an S corp.
Yeah.
Why should someone never form an S corp?
The main reason nobody should set up an S corp is because, first of all, there's no such thing as an S corp, right? It's just a corporation that has what's called an S election. But you can have that election be made with LLCs, with partnerships, with corporations. So that doesn't matter. So the reason we don't like to use S corps is for asset protection purposes. Charging order protection does not apply to corporations. So if you have a corporation or an S corp and somebody sues you and has a judgment against you, I can go to the judge and say, hey, he has his S corp, give me those shares. The only state that's not allowed is in Nevada. So if you have an S corp, here's my recommendation. If you have an S corp and you're like, oops, I shouldn't have set up an S corporation, I should have set up an LLC and have it taxed as an S corp, which is what you can do. What you may want to consider is redomiciling it to Nevada, because at least there they'll give you that charging order protection. But if you have an S corp in any other state and there's a judgment against you, they're going to go ask for those shares, the stock, and they're going to get it.
Yeah. And so, and correct me if I'm wrong here. So Summers Capital is an LLC, but we file as an S corp.
Correct.
That sounds like it gives you all the asset protection, liability protection, but then it gives you the tax benefits of filing as an S corp. Is that correct?
That's exactly right. So if your CPA, your tax professional says you need an S corp for tax purposes, great. Set up an LLC and have an election, have it taxed as a corp. That's the beauty of LLCs. They're so flexible that you can have it taxed any way you want. If you're a single member, it's disregarded, but you can have it taxed as a partnership, as a C corp. or as an S corp. I mean, that's the flexibility that LLCs provide.
Yeah, I love that. Okay, so next up, there's a lot of we're going to switch gears here a little bit, and we're going to talk SEC. We're going to talk about raising private capital, the do's, the don'ts. There's a lot of ways to get in trouble here in the eyes of the SEC if you don't know exactly what you can do and cannot do. So, what are some of the do's and don'ts of raising private capital?
The first thing is understanding that you're selling securities. That's probably one of the biggest mistakes. One of the biggest mistakes I see people raising capital, especially smaller amounts, is they just don't even realize they're selling securities. They're doing promissory notes, or they're doing joint ventures, or they're doing all these little things that they don't even understand that they're actually selling securities and need to comply with securities law. So I would say that number one. Number two, this idea that a joint venture somehow is not a securities offering is another one. A lot of people, when they start out, they do joint venture agreements, right? But most joint venture agreements that I see are just securities offerings in disguise. So calling something a joint venture doesn't make it a joint venture, right? In order for it to be a joint venture, all of the partners need to be actively involved. Everybody has to be rolling up their sleeves. It's not a securities offer. So that's number one. Number two, we talked a little bit about last time as well. Number two is just paying people to raise capital for you. Like, that's a no-no. Like, you generally have to have a license to go raise money for other people. Just like you need a legal license to practice law, a medical license to practice medicine, you need a broker-dealer license to go raise money for other people. Sponsors and syndicators who are doing their own deals, they have an exemption to that. It's called the issuer exemption. But if you're just there primarily to bring in the capital, you don't qualify for the issuer exemption, and therefore you need to have a broker-dealer license. Now, with Trump in office now, I'm hopeful that one of these proposed rules that came out will pass now and will allow you. There'll be an avenue for you to actually get compensated to raise money for other people. But as it stands today, you cannot do it without a broker-dealer license.
Hey guys, for the first time ever, I'm teaching a group of driven creators how to build a seven-figure brand. When I went all in on my content only 24 months ago, I 4X'd my real estate portfolio, grew my team, and even hosted industry leaders like Grant Cardone on my podcast. Now I'm showing you how to master social media, podcasting, and brand building with proven strategies and a supportive network of business owners. Join a community that's just getting warmed up with 40 plus members and growing. So if you want to learn more to see if we can help you, visit the7figurecreator.com to book a free call with my team. Again, it's the 7, spelled like the number 7, figurecreator.com to book a free call with my team. Now back to the show. You mentioned JV is one of the biggest mistakes that you see out there. A lot of people think it's a JV, but it's really, they got a lot of partners in that deal that are only thing they're bringing to the table is capital. And so you're saying, from a liability perspective, if that deal goes south, a lot of those capital partners that are JV partners, quote unquote, there's a potential lawsuit there waiting to happen, is what you're saying.
100%, because what'll happen is the other partners that are really just limited partners because they're not doing any work, they're all eventually going to go hire a lawyer and say, hey, I lost my money. What's my recourse? And they're going to look at this and say, wait a minute, did you get a PPM? Did you get all the disclosures? Like, no, we just have an LLC. And they're going to have basically an unregistered securities offering because, again, just calling it a joint venture doesn't make it one. Anytime you're taking money from investors where the returns are generated by your efforts, you're doing all the work and your investors are just writing you a check, that is a securities offering. That is a syndication, right? So in order for it to not be a syndication, you need to pool money where everybody's actively involved, everybody's rolling up their sleeves. Ideally, it's proportionate. I mean, it doesn't have to be equal, but if I'm putting in 10% of the money, I own 10%, I'm doing 10% of the work, we're all qualifying for the loan. Think of it on a joint venture, think of it more as business partners, not investors and sponsors or GPs and LPs. It's a business that you started and you have business partners. So everybody has to be pulling their own weight so that the returns are generated by everybody's efforts and not by the efforts of a sponsor.
Yeah. And so if you're a general partner out there, you're a sponsor, you're a principal in a deal, make sure that you get with an SEC counsel, the right SEC counsel, make sure that you got a legitimate PPM, a legitimate subscription agreement, and your investors know going in what they're signing. I get this question all the time by like new limited partners, like, hey, like, because it's intimidating, all the paperwork. It's 75 pages. And they're like, hey, like, what does all this mean? This is intimidating, a lot of scary language. And I just tell them, like, look, generally speaking, what it means is this. I'm like, basically, you can invest in this deal, you can lose 100% of your money, and you can't sue me. Generally speaking, is what it means, right? But I always say, hey, consult with, your own counsel, review it if you don't understand it. But that's generally speaking what it means. And that's really what it means, right?
Absolutely. That's
worst case scenario.
It's just all of the ways the deal can go south,
Yeah.
all the important information that they need to make an intelligent decision whether they should invest in this deal or not. There are plenty of lawyers out there that will review PPM documents for you, and maybe $1,000 or $1,500. So if you're concerned about that, but that's also a red flag. We're talking a little bit about red flags, but one of the red flags of a syndication is if they don't have the documentation. Like if somebody comes to you and says, I'm raising whatever I'm raising and you're a non-accredited investor and there is no PPM, that is a huge red flag. Like I would run in the other direction. Back when I was a younger lawyer, I was reviewing other people's deals. And every time I saw something like that where there wasn't a PPM and there was an excuse as to why one wasn't needed, both of those instances, there was some kind of a fraud involved. There was some kind of, shenanigans going on the back end. So anybody that's cutting corners on the important part about compliance, that to me is a red flag.
Yeah, absolutely. I think if you're out there raising private capital for any real estate offering, you got to make sure that you got your documents, sub-agreement, PPM, work with your SEC counsel early and often. And one thing I do hear people doing, which I'm like, you're fucking crazy, is they're like, oh, like I'm going to save $20,000. I'm just going to go borrow someone else's documents. I'm going to change the property address. I'm going to change the LLC names. I'm like, dude, that's something I wouldn't want to mess with.
I wrote an ebook called The 5 Things Every Syndicator Must Know to Stay Out of Jail. And that was number 5, using PPMs pulled from the internet or whatever. I mean, the PPM itself is just a vehicle. It's a pipeline. It's a pipe. Like it's what you put in to the PPM that's important. It's what disclosures are you going to give. And the only way you know what disclosures to give is to talk to a professional, an attorney who can ask you the questions, review all your materials and say, okay, these are the important things that we need to put in the disclosure documents, even though you may not want to. These are material facts for your investors and they have the right to know. And for your protection too, because if you give them all the information and the deal goes south, hey, I gave you the risk. I told you could lose all your money for all these different reasons and you still decided to invest. If you leave some of that information out and there's loss of money, even if it doesn't even relate to that, trust me, the plaintiff's lawyer they're going to hire, they're going to blow that issue up and then they say, hey, had you disclosed this, my client would not have invested in your deal. And therefore, you're responsible for returning my money plus interest, and you're probably going to be barred from raising money ever again.
Yeah, absolutely. Yeah, so that's how I frame it to investors. They ask me, new investors, I'm like, basically in a nutshell, what the 75 pages says is you can lose 100% of your money and you can't sue me. Okay, so one other thing you said, which I find is kind of a gray area. You said, some investors or GPs don't even know that they're selling securities, i.e., promissory note. Or a second mortgage on the property, etc. That is kind of a gray area, and I've heard different people say different viewpoints on this. So, what exactly constitutes or defines whether you're selling securities or not selling securities?
Whether something's a security or not comes down to what we call the Howey test, and my English definition, because I'm known as one of the few lawyers that actually speaks English, is anytime you take money from investors where the returns are generated by your efforts, you're doing all the work, they're just giving you a check. That is a securities offering. The structure itself does not matter. It could be in the form of a LLC or a promissory note or a side agreement or a wink or a handshake. It doesn't matter. The SEC is going to look right through it and said, who is the one generating the return? If it's one or two people, they're the syndicates, then it's a securities offering. Now, promissory notes are very nebulous. I will agree with that. The rule is, well, first of all, the rule is there is no rule. So the courts basically, you'll laugh at this, the courts basically say, if it looks like a security, it walks like a security, and it talks like a security, it's probably a security. That's kind of what we're going on. Now, there are some black and white stuff. So, for example, notes that are less than 9 months are, by definition, not a security. So if you're giving me a loan and it's one person and one property, whatever, and it's less than 9 months, that's probably fine. Generally speaking, if you're securing the promissory note in a first position deed of trust with the property, it's a security, but you get to rebut that presumption. It's presumptively a security, but you get to overcome that.
Because how is that difference from like a private lender?
Correct, that's exactly right.
That does a bridge loan, is in first trust deed, or even second trust deed position on property. These private lenders that are the bridge lenders, that's not a security.
That's correct, because it's one of there's a Supreme Court case called Reeves that goes over these factors, not factors, but like these family resemblance tests that say if it looks like one of these things, you're probably good. One of them is a note secured by a mortgage. So that's where that one comes into play. But everything else, man, if it's not secured, if it's secured in second position, if it's multiple, if it's a fractionalized note, it gets really, really nebulous. And again, it comes back to at some point, how risk averse are you? Are you conservative? Are you aggressive? Because if you're conservative and you want to stay way away from the gray zone, then you probably shouldn't do it. And if you are a risk taker, just like an investor has different risk tolerances. It's the same thing when you're talking about the law. How aggressive do you want to go and how much do you want to push the envelope?
Yeah. So in regards to raising private capital, one of the most common offerings is a 506C or 506B offering. 506C allows you to market and solicit all you want, your offering, but you can only bring in accredited investors. However, on the other side, the 506B allows you to bring in up to 35 non-accredited investors. However, you cannot go market and solicit the opportunity. That said, I guess first things first, what constitutes the difference between an accredited investor and a non-accredited investor?
An accredited investor is anyone who has $1 million in net worth, excluding their primary residence, or has earned $200,000 a year for the last 2 years with a reasonable expectation of earning that much this year or more. And if you want to combine your income with your spouse, that number goes up to $300,000. There's also recently, 2 or 3 years ago now, they expanded that to include certain licenses. So if you've got some securities licenses, a Series 7, Series 82, Series 65, in good standing with your state, you're also an accredited investor. They're trying to expand that. At some point, they were saying maybe if you're an attorney or a lawyer, the SEC said no, we're going to keep it at this for now. But generally speaking, for individuals, that's what an accredited investor is. And if you're investing through an LLC, an entity, generally speaking, all of the members need to be accredited for the LLC to be accredited, or the LLC has $5 million in assets that were not specifically raised for the particular investment. So if you have a medical office, practice or whatever, and you've got a bunch of doctors or a business that has $5 million in assets, then it's going to be accredited by definition.
Got it. Okay. So if there's 3 members investing into an LLC and they want to invest as an LP, their accreditation, would it be the sum of all 3 of their net worth, or would it be each of the 3 have to qualify individually?
Each of the 3 would have to show that they are accredited. If one of them is not accredited, and the LLC as a whole is not accredited.
Got it. Now, husband and wife, they have to hit $300,000.
If they want, they don't have to. But if you want to combine it with your spouse,
net
so
worth,
for example, if you're one of the spouses, let's not be just which one, but one of the spouses makes $220,000 a year, the other spouse makes zero. The 220 person isn't an accredited investor because they make only 200. The spouse is not an accredited because they make zero. And the other one can't even combine it because they even combined, you're at 220. So the spouse that makes zero is going to never be an accredited investor, but the one that makes the 220 can qualify individually, so they would be an accredited investor. They don't have to use their spouse.
Got it. Okay. And so the SEC also has language in there when we're talking 506B is any non-accredited investor that comes in, you have to have a pre-established or pre-existing relationship with. What, by definition, does that mean?
So generally speaking, if you have a pre-existing substantive relationship, the SEC believes that you did not advertise or generally solicit, which is the main limitation. So if you can show that you have a pre-existing relationship, you're in good shape. That's why everybody goes after it. This is one of the few areas, I believe, this is one of the few areas where the SEC has given us some really good guidance. And they've come out with basically these 8 steps that you take. And as long as you take these steps, you can show that you have a substantive relationship with this person. And then, of course, that relationship has to be pre-existing, so prior to the offering. But the main ones are basically, they said, look, you want to have a bunch of phone calls with you. You got to get to know them, right? You want phone calls, lunches, coffees. You probably go to Starbucks with them. You want to send them a questionnaire to kind of, again, understand what type of investor are they? Are they a growth? Are they conservative? Are they cash flow? Like, what does that look like? You want to have offline communication with them. But there's all these factors that the SEC, they basically want to foster that relationship. They're looking for how good is that relationship between you and the investor so that you can determine whether your investor is sophisticated. And they want to be asking you questions. Hey, are our values aligned with, because again, if you're a 80-year-old widower and need cash flow, you should not be investing in a ground up development or even a hotel that hasn't even been built yet. It's not going to have cash flow for 2 years, right?
What's 1 or 2 mistakes that you see new syndicators make in the legal space, whether it's raising capital or asset protection? What's the biggest mistake that you see a lot of syndicators making out there?
The biggest mistake on the asset protection side is just believing that a living trust gives you some sort of protection. Living trust has no asset protection value whatsoever, zero, zilch, nada. So that's probably one of the mistakes there. And then I think on the syndication side, especially newbies, for some reason they just think they can start using social media to start advertising their deals. And I think using social media, especially with a 506B, because 506B prohibits you from advertising and generally soliciting. And for some reason, there's a disconnect. They don't think of social media as advertising, I guess. But the definition of an offer from the SEC, again, extremely broad. They can pretty much say anything you put on social media is an offer. So just be super careful if you're thinking about raising money under a 506B. Just stay off social media. Like, just you can post about your cat. You can continue yours post, Rich, of your yacht and the good times you have in Catalina. But just don't talk about the deal that you have. Just stay off social media if you're doing a 506B. On a 506C, of course, knock yourself out and do whatever you want on social media.
Yeah. So I when I first started raising money, I did a 506B, and the second one was a 506C, and then I went back to the B for a little bit. From this is my personal experience. What I would say is this: as a real estate investor, a newer syndicator raising money, I think it's for the first couple, it's easier to raise money with a 506B because who's going to invest with you early on? It's going to be people that already know, like, and trust you. And so you're less likely to attract a accredited investor that doesn't already know you. And so I think early on the 506B is the route. But then as you start to get a little bit of a track record, as you gain a little bit of trust, you can start to attract accredited investors that you don't have a track record with because of your track record. And then I think it makes more sense to kind of transition over to the C. Also, from a liability perspective, the C, there's a lot less ways to get in trouble with a 506C. So, now we're like, our fund is 506C. I don't think I'll ever go back to a 506B at this point.
I would agree with that. I think people have this notion that, oh, it's a 506C, I can post my deal on social and I'm just going to get it funded in 24 hours because I could just promote it to everyone and all these people are going to see it. To your point, people invest with people they know, like, and trust. It takes time to become a thought leader, put your content out there, put content not about your deal, but content about what you do. You do just a masterful job on social media, but it's not about the deal. It's, why multifamily or why boutique hotels, why whatever state you're in, or, the reasons why you love real estate, the tax benefits, the bonus, all that kind of content makes you an expert so that at some point in the future, when you have a deal, they'll at least recognize who you are. And it's like just some new person that's suddenly putting an ad on Facebook and that they never heard it before. So yeah, most of my clients would start with a 506B because inevitably they have friends and family and somebody, their Uncle Bob and Karen, that somebody's non-accredited, their parents or whatever. So usually people start 506B, but at some point they grow to a point where they've exhausted that list and they need to expand that list. And hopefully during that ramp up time, they've been on social media, getting their presence known. So when they make that transition, they've got a little bit of a presence somewhere on social media.
Yeah, I agree. I think it's definitely a limiting belief. And I've been there and I've made that mistake where I had just done a raise. It was 506B and it was pretty successful for the first raise. And 3 months later, I'm doing another raise and I'm still very green at this time. And I think, oh, let's do a 506C. We can market, solicit, and it's just the money's going to come. It was very challenging, that raise. And it was kind of it was a wake up call for me. And I realized, you know what, you got to have the track record. You got to have been doing this for a little bit. You can't just go on social media and talk about your deal and people are going to invest. You got to have the established wherewithal. Otherwise, it's going to be very, very challenging to attract accredited investors that don't already know you.
And same thing with a fund, by the way. Is people are like, hey, do I do a project-specific syndication or do I put together a fund? It's very difficult to put a fund together when you're just starting out. When you don't have that track record, most people start off with a project-specific. They identify a property, they do their 506B, and then at some point when you have the track record, people know you, like you, and have invested before, and you've shown them good returns, then maybe you graduate to some sort of a fund. Yeah, that's something that a lot of people say, I want to do a fund. It's much easier, I think, these days to raise money for a project-specific deal. If you can pull off a fund, knock yourself out. It's amazing, but much harder to do.
Yep, absolutely. So you got a piece of video that did really well on social media I want to touch on, and the topic was, you were talking about the secret success to waking up at 4 a.m. Tell me what is this? What is the secret success to waking up at 4 o'clock in the morning?
Yeah, I think that was a Brandon. I think Brandon asked me, like, is the secret to success waking up at 4 o'clock in the morning? And I think I said no. I get up super early. Like the other day I was up at 3:30. Like
3:30,
4 a.m.
What are you doing at 3:30 in the morning?
I'm a 4 a.m. I'm part of the 4 a.m. club, right?
Okay.
Sometimes 3 a.m.
3 a.m. Damn.
I've done it 2 a.m. a couple times, but
what are you doing at 3 o'clock in the morning?
Nobody's bothering you at 3 o'clock. Again, it's not usually at 3 o'clock, but let's say at 4 o'clock, you get up, I'm having my cup of coffee, I'm getting down, I'm settling down on my thing, and then I do all the stuff that I like to do. Like I'll do my personal development stuff. I love to read. I'm always reading books. And I don't do emails or anything. And then I like to create. This is where I do my dreaming. This is when I do my vision board. This is when I, create, what I'm going to create, because there's no interruptions and there's nobody. The kids aren't awake. I mean, that's where it started. Is when I had little kids, because at some point I was waking up when the sun woke up, and then the kids came in, and so I'm like, well, I get up at 6 a.m. I got to start getting up at 5, and they started getting up at 5:30. So I just kept going back and forth. But it's just an amazing time. And then I love to go. I know you're a big hiker, and I love to go walk on the beach too. And to me,
sunrise hikes.
I haven't. Yeah, the hikes where it's first light. Like I love to get down on the beach right at first light. And then to see those colors pop up, it's also, and again, to me, it's actually therapeutic more than anything else. Yes, it's a good workout, but really therapeutic to go do that. So I just enjoy it. Is it the secret to success? I don't think so. I've got people that I know that are the opposite. They'll go to bed at 2 o'clock in the morning, 3 o'clock. That's when they're most productive. I'm just more productive from the hours of like 5 a.m. to 10 a.m. That's when I'm the most productive. I'm fresh. My creative juices are flowing. By 3 o'clock in the afternoon, man, I'm done. Like I go to bed early too. Like I'm in bed. I got little kids too, so I'm in bed by sometimes 8, 9 o'clock at night.
How
I
old
get
are your kids?
My kids are 10 and 8.
Okay.
So, but I still get my beauty sleep. I'm still getting 7 or 8 hours. It's just I go to bed early and wake up early. And if I've got something on my mind, I might get 6.5, 7 hours, and that's when I'm up at 3:30. But it's all natural. Like I don't set an alarm. It's just if I wake up and like the other night I woke up and it was like 3:20 or something, and I'm like, oh, I'm gonna go back to sleep, and I'm like, I'm awake, so let me just get up. Like why not? I enjoy what I do. I look forward to the day. So let's get going, and that way I can get a head start on the day.
Yeah, I'm with you on that. I think I used to be in the boat of like I'm more of like a night person, and I would get my work done like my best thinking at night. But as I've gotten older and like a little bit more seasoned in the game of real estate and business, I find that I'm waking up earlier and earlier and earlier, and every time I'm like, oh man, like I need to find some more time. Often the solution to my problem is okay, just wake up an hour
Yep.
earlier. And so, but I'm not 3:30. I would say for me, I'm up around 6. If I get up before 6, I'm moving the needle for the day. But for me, I'm like, I wake up, I go straight to the gym. I don't BS with all these morning routines and all that sort of stuff. I don't do the cold plunges and all that. I just believe in like literally waking up, go straight to the gym, get the workout in, get the lift in, come home, shower, come to the office and start my work, start my productivity. And I would say most of the people in the office come in here around like between 9:30 and 10. So if I can get in here before 9:30, I don't have all the distractions of being pulled in all these directions, and I can just like work and get some stuff done. So for me, earlier the better. And then with the time change, I must say, now it's dark at 5 o'clock. I'm like, there's no work getting done after 5. I'm not even going on hikes. I'm not even doing exercise after 5. So it's even more reason to wake up early this time of year.
Yeah, but like I'm a good friend of mine, Robert Helms. He likes to say he likes to get up at the crack of noon.
What does that mean?
It
Like
means he
waking
gets
up
up
at noon?
really late, but he's
Yeah.
also at 3 o'clock in the morning, 4 o'clock. He's still grinding.
still
That's
working.
that's his time. He's a little bit more of an artist, so that's fine. So whatever works for you, man. I think too many people look, to your point, other people's routines and other people's styles. Like what's right for you. And if you're a morning person, that's when you're more creative. Get up early. If you're a night person, get up night. Don't let anybody criticize you. Do your own thing.
What's it like working with Ken McElroy here?
Ken's amazing, man. I've known Ken for a long, long time, and he's just become a mentor of mine. And he's just his YouTube channel's been blowing up lately. And so it's funny. I've been trying to convince him to do 506Cs. He's always in 506Bs, and I've been like, dude, you've got an audience now. But he's just a really good guy. We actually hit it off a long time ago. He's got 2 boys, and when I first met him, they were young. They were in their teens or whatever, and he has just the most amazing relationship with his boys. And that's what I would ask him about. I'd be like, how do you do this? What are you doing? How are you relating it? Because I wanted to have kids. And so I've learned a lot from him from that point of view, the mentorship of how to become a really good father, good business person. That's where I really, and he's just a great guy, overall guy.
Yeah, absolutely. Mauricio Rauld, man, I appreciate you coming on the show. Appreciate you taking the time to drive down from San Clemente. Next time I'm up in San Clemente, I have to hit you up. Maybe we can connect.
I'd love to.
We'll be up there for Thanksgiving. I'll be up there for Christmas. My family's out there.
Yeah.
My sister lives off of Pico. My parents live off of El Camino Real, so we'll definitely have to connect. And I want to say thank you again for coming on the Boutique Hotel Investing 2-day webinar that I hosted last weekend. That was really amazing. And you came on and spoke on our mastermind call as well. So thank you for that. Where can the folks get in touch with you if they want to learn more?
Just go to askmauricio.com if you want to get a hold of me, and just go to the YouTube channel. I mean, I've got a ton of videos on there in terms of content stuff. So YouTube channel, or if you want to get a hold of me, go to askmauricio.com.
Ooh, I like that website. It's a good domain right there. He's Mauricio Rauld. I'm Rich Shermer's listeners. Thanks for tuning in. We'll see you in the next one. Peace.